The difference between being a secured creditor and an unsecured creditor in the case of a debt owed by an insolvent company or individual can have significant legal and financial consequences. In general terms, a secured creditor is a party that has a security interest over the assets of a company or individual, which entitles that person to require those assets to be sold in satisfaction of a debt. An unsecured creditor, whilst legally entitled to the repayment of a debt, has no such rights in respect of the assets of the company or individual. In the event of insolvency, a secured creditor takes priority in the distribution of the assets of the individual or company over and above the unsecured creditors. What this usually means is that secured creditors have a much better chance of receiving some portion of the debt that is owing in the case of insolvency, whereas unsecured creditors are often left out of pocket entirely. It's not uncommon for directors of insolvent companies or individuals who are soon to become insolvent to make payments to related parties or themselves over and above and in priority to unrelated creditors. In these circumstances, it's common for a liquidator or a trustee in bankruptcy to make an unfair preference claim against the recipient of those payments. Another one of the major benefits of being a secured creditor is that repayment of those debts are not subject to unfair preference claims, so it's one less thing to worry about. If you're proposing to enter into any sort of commercial arrangement which might give rise to a debt or liability, you should seek legal advice to ensure that your debt is properly secured.